Hello. Hello.
Good morning. The meeting will begin at 9:30 when everyone else logs in. Thank you. Hi, everyone.
Hello. I've been trying for an hour to log in. I can't seem to get in. So I hope this phone is acceptable.
We can hear you.
Thank you.
Will we have sharing rights?
No, we do not. We do not have sharing rights for users. We share. Planning Commission is the only people that share.
Okay, so you have our documents, right?
I'm sorry. Who is this speaking?
I'm sorry, Roseanne Potter, CFO of the Cleveland Foundation.
Oh, yeah. Of course we do.
Okay, great. Thank you.
Sure.
You guys hear me? Can you hear me?
Yes, we can.
You can hear me?
Yes, we can.
Okay.
Maurice, before we start, just a quick hello from your neighbor.
Good morning. Good to see you.
Great to see you.
Mr. Kelly.
Morning, Maurice, can
Kevin.
you hear me?
Yes, we can. Good morning. I'm glad you're still down at the end of the street.
Yeah, I'm not going far.
Good.
Good morning, Maurice. How's my sound level?
You sound great.
Okay.
And good morning.
Good morning. I'm a little congested, but I think I'm going to be okay. Thank
Okay.
you.
Good morning. Can you hear me?
We sure can. Loud and clear.
Okay, I can't see anything yet. Is that right?
No, you
All I
should be able
see
to
is-
see things.
I just see the City of Cleveland zoning logo. That's all.
Yeah, that's our presentation.
Oh, okay. Okay. All right.
Good morning. Am I clear this morning?
You sure are. And good morning, Miss Barnes.
Good morning. This is Andrew Fauerbaugh with respect to MEDA.
Good morning. Which case?
Okay, this will be MEDA, MEDIA LLC.
Oh, okay. 22-012. Okay, thank you.
Very good. Yeah.
I think we'll get started at 9:30 as soon as all the board members are logged in.
Okay, Liz, it's 9:30. We can get started. Good morning.
Good morning, thank you. My name is Liz Kukla. I'm the Secretary of the Board of Zoning Appeals, and I'm going to read the preamble for you this morning, this Monday, February 28th, 2022. In compliance with notification requirements of the city's open meeting law and section 101.021 of the codified ordinances of Cleveland, Ohio, 1976, notice of this meeting has been publicly posted. All boards and commissions under the purview of the City Planning Department conducts its meetings according to Robert's Rules of Order. Actions during the meeting will be taken by voice vote. Abstentions from any vote due to a conflict of interest should be stated for the record prior to the taking of any vote. In order to ensure that everyone participating in the meeting have the opportunity to be heard, we ask that you use the raise hand feature before asking a question or making a comment. The raise hand feature can be found in the participants panel on the desktop and mobile version and activated by clicking the hand icon. Please wait for the facilitator or chair to recognize you and be sure to select unmute and announce yourself before you speak. When finished speaking, please lower your hand by clicking on the raise hand icon again and mute your microphone. We will also be utilizing the chat feature to communicate with participants. The chat feature can be activated by clicking the chat button located on the bottom of the WebEx screen. Please note that calling users can unmute by using *6. All meeting activity is being recorded via the WebEx platform. These proceedings are also being live streamed via YouTube for public view. We have provided a link to the meeting for those who wish to speak on a particular case via our website and email. All requests to speak on a particular matter have been considered. We've also received emails from those who have provided written comments on a particular matter. Back to you, Madam Chair.
Thank you. Go ahead, call the roll, please.
Thank you. Ms. Barnes,
Here.
Ms. Brown,
Present.
Ms. Faith,
Present.
Ms. Britt.
Here.
Madam Chair, we have a quorum,
Thank you.
and we have no postponements or withdrawals today.
All right.
I do see Councilman Mooney. I think that is the only council person I see.
Okay, well, we'll start with his case.
I saw him as well. So just for everyone, as a courtesy to the council people, we move their cases to the front of the line so that they may go about their days afterwards. So we'll begin today with calendar number 22-012. This is at 11500 through 11508 Lorraine Avenue. This is a violation notice. Media LLC owner appeals under the authority of Section 76-6 of the Charter of the City of Cleveland and Section 329.02D of the Cleveland Codified Ordinances from notice of violation number V1903-4271 issued on October 7th of 2019 by the Cleveland Department of Building and Housing for failure to comply with Section 327.02C of the Cleveland Codified Ordinances, which states that there shall be no change, substitution, or extension in the use of any building or premises until the required use permit and certificate of occupancy has been issued by the Division of Building and Housing. This was filed November 12th of 2019. And with that, to Ms. Brown for the oath.
Good morning. I'm swearing in all who are present for this case. Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth? Please raise your hand. Reply, I do. State your name and your address, please.
Yes, I do. And my name is Yair Gun. I represent Mayday LLC. Address is 730 Minor Road, Cleveland, Ohio, 44133.
Brian Mooney, 3402 West Boulevard, Cleveland Council, Ward 11.
Anyone else?
David Rogers, Westtown Community Development. My address is, my Cleveland address is 3785 West 128th, representing here the community, Westtown Community Development.
Thank you. Okay, Madam Chair.
Thank you. Do we have any background on this case, Liz, since we don't need the?
No, Madam Chair, but I do see that the inspector is online here and he may want to speak. I'm not sure if he's having technical difficulties or if he's chosen not to speak on. It's Mr. Madancic.
Yes, can you hear me?
He should be sworn in, please.
Yeah,
He did try to say yes, but he's very faint. If you could speak up a little bit, sir.
Can you hear me?
Sorta.
Very faint.
Inspector Madancic, City Housing.
Let's see.
I heard that very faintly, so hopefully you can work on your sound while we're getting everything else together.
You might also want to try calling in if you can increase the volume on your microphone.
I'm working on it.
You should have it right there. Okay, all right, legal standard, please.
Thank you, Madam Chair, members of the board. Appellant is appealing an administrative decision. The standard of review to be applied is whether the administrative decision was illegal, arbitrary, capricious, unreasonable, or unsupported by the preponderance of substantial, reliable, and probative evidence. If the appellant fails to meet this burden, the administrative decision must be affirmed.
Thank you. Who will be the spokesperson for this case?
If I may, I'm the attorney for Meta LLC.
And what's your name?
He didn't swear in, Madam Chair.
He's an attorney. He doesn't need to.
Okay.
I'm not going to be presiding testimony. I'm just going to put forward the position of Meta LLC. I'm Andrew
Okay,
Fauerbach.
okay, Andrew. All right, thank you. Go ahead.
Okay. The position of Meta LLC is that they have, pursuant to the lease they have with the tenant at that location, and given the nature of the violation regarding the tire shop, that was the obligation under the lease for the tenant. And for that purpose, Meta LLC is pursuing its remedies by evicting that tenant. Its obligations under the lease, it has provided them with a 30-day notice of default and an opportunity to correct. At this point in time, the tenant has not corrected, and a 3-day notice to vacate was posted this weekend with the running of the 30 days under the lease for them to correct. And Meta LLC intends to pursue an eviction of the tenant and then proceed to a remedy if anything's left behind at the premises with regard to the tires. That's essentially the position of Meta LLC, is that as the landlord, they can't go on to the premises and correct until such time as they have gotten a court order. And we are using, we have spent the time we've had pursuing that rigorously and promptly. The lease like many commercial leases, provides a 30-day period for the tenant to correct. That notice was promptly given after the receipt of the violation, and with that failing to correct by the tenant, the 3-day notice to vacate has been issued, and that was this weekend. So an eviction in Cleveland Municipal Court will be proceeding by the end of this week or beginning of next week.
Lori, I have a question. With that information, is this still should be in front of us today?
Yes, legally, the landlord is responsible for what's going on his property. I did have a couple questions that I think maybe we want to look at here, and it's indicating, and Liz, correct me if this is wrong, but filed November 12th, 2019?
No, I have a violation date of December 27th, 2021. The violation.
Madam Chair, to Ms. Wagner, on the first page, it says January 25th is when it was received by our office. You can see the blue stamp there.
Okay, then the agenda must be mistaken. That doesn't change my opinion. The landlord is responsible. However, the board can take into consideration what steps the landlord is taking to resolve this issue.
Well, let me clarify a little something. As a landlord, we can't go on and remedy until we get permission from a court to go onto the premises and take control. The typical commercial lease that exists between Meta LLC and the tenant does provide the 30-day remedy period. The notice of default was issued so that at the beginning of January, so that, let me get the notice of default. the notice of default was posted January 22nd, and that time is run the 30 days they had under the lease to correct. And and now they have the 3 days under the notice to vacate, which is both of which are legal requirements. So as far as the running of time, I think we've been pretty prompt in pursuing that, as well as eventually pursuing the eviction to remove them. And then MEDA will have the ability to go onto the premises and resolve any violations.
Yes, that does, like I said, that does not change the legal liability here. I think that's something the board's going to want to look at, and maybe the councilman and other people have more information on this, whether they were keeping track of what was being done there. I mean, they're responsible if their tenant doesn't get a certificate of occupancy. But the board is certainly going to want to take into account what measures the landlord is taking to comply with the code.
Thanks, Lori. So, Mr. Firebar, are you saying that at the time the violation was was given, that this tenant was in violation, but what you're trying to do is evict the tenant that got this violation? So is that your stance right now?
That is our stance. That's correct. And the ability under landlord-tenant law to go on to the premises and correct it requires us to go through the eviction process beforehand.
Okay.
That would be correct, but as I said, under the law, the landlord is responsible, and I think the board needs to develop the information here as far as how long this has been going on, and whether the landlord knew or should have known what was going on in his building. So I think, but you can't dismiss it just because the landlord is going to evict the tenant. You certainly can take that into account. I think it would be useful for the board to hear the councilman and the neighborhood group.
Yeah, I was just trying to make sure that they are stipulating that they're not actually appealing the actual notice per se, because the notice for certificate occupancy is correct, that they did not have one. So I just wanted that for the record. Liz, were you about to say something?
And Madam Chair, the other comment is that the appellant may not be asking for it to be dismissed as much as they're just asking for more time, similar to what the Board of Building Standards does, in that they allow more time for violations to be fixed. However, as Lori can testify to, the standard of review here is whether or not the city was arbitrary or capricious and did something illegal in this case. But it sounds like the appellant is not arguing that per se. It sounds like they're admitting that the violation notice was officially cited. Just seems that they are going to comply once they have more time. Correct me if that's wrong. Thank you, Madam Chair.
Yeah, that is our position, and it is essentially we need the time to follow the legal procedures to correct the issue. With the notice of violation, and what I'm looking at on the notice of violation says issue date of December 27th, 2021. I think we've been prompt, both my client in getting in touch with council, as well as getting the necessary notices drafted and posted that the lease required. And so in that sense, if we could be given enough time and revisit this matter in 60 days, we should have probably some resolution of the forthcoming eviction action.
And Madam Chair, one more thing to the board members that may not know. When a violation notice is issued, the owner has a certain amount of time to comply. And so if they don't comply, it can be prosecuted further. So they could possibly have to go to housing court, or there may be some fines or whatever. So the interest here is to not have that next step proceed.
Madam Chair.
Okay.
Madam Chair, this is Richard Riccardi.
Oh, Mr. Riccardi, go ahead.
Zoning Administrator. Pursuant to Zoning Code Section 32799B and Building Code Section 3103.09E1, The owner is responsible for the violations. The owner cannot, I mean, basically is not contesting that the violation is there. He's saying he made some contract which relieves him from immediate liability from these violations, which is his legal responsibility under those sections that I cited. This violation notice should be upheld and this appeal dismissed. And if the city chooses to prosecute this violation, those arguments can be made to the housing court. But by delaying this or by dismissing it, we're saying that we can't prosecute these violations. That's not the way the ordinances are set up, and that's not the legal standard. So I would ask that, especially since there's evidence that these violations are in existence, that this violation notice be upheld. Thank you.
Thank you, Mr. Riccardi. I'm gonna just for some context, I'll ask from the CDC, David, do you want to weigh in here?
The community's perspective is, that's fine to correct, the violations. I mean, it should be noted too, this is a historic district as well. I know this isn't necessarily a forum for that, but from the community's perspective, I understand, Medea's wish to get rid of the tenant, but without a proper filing of eviction, I mean, that's just a 3-day from the attorney, no disrespect, but I mean, without a proper filing, we don't really know moving forward that that's going to be an expedient manner to correct the violations. So like Mr. Riccardi was saying, I mean, the fact of the matter is the violations still exist. And with this nebulous time frame of an eviction, we don't know that would correct them. So there, on our perspective now, hearing this with this lease agreement, it's, it doesn't give like an immediacy to the time for, like, we don't get any kind of time frame out of that. But the bottom line is that the neighbors are complaining about several issues there. And again, this isn't necessarily, housing court, but the issue with the tires and traffic in and out of the back of there, and the signage, which is not displayed on these photos. And I have a photo of the signage issues on the side of the building, is become an issue with another of the tenants there, which also had a complaint about, and I don't know if you can really see this, but there's signage on the side of the building, not even on, which is another unit altogether. And I know the landlord easily understands that. So, it's just basically the long and the short of it from our end is we just want it cleaned up. But with an eviction, that's kind of nebulous, because we're not going to get an immediate time frame, and that's through housing court and their magistrate. So we won't really know when the correction, when the stuff would be corrected. So that's the only concern there. I understand moving forward that that's the route you want to go, and that's sensible if you're not getting compliance from your tenant, but it doesn't give us like any kind of time frame, and without the tenant being present, it's the bottom line is, like Mr. Riccardi said, the violations and the issues here, they are on the landlord. So that's just kind of a quick of our perspective.
All right, thank you, Mr. Rogers. Councilman Mooney?
Thank you. I mean, this is mainly a legal argument, so I would defer to our attorneys, but I in theory support Rick Riccardi. They're not being punished here, the landlord, for these violations. There's no action in housing court. And if there was action in housing court, I would urge to have some leniency to give them a chance to comply and do their due diligence with the eviction. But I would just echo Mr. Riccardi's statements. I mean, this has been here for, I don't know how long, at least a year and a half, the tire shop, and they're installing tires in the back, and there's signage issues. Other tenants of the same landlord are complaining about this shop and neighbors. So I would just, urge the board to follow Mr. Riccardi's recommendations. Thank you.
Thank you. Mr. Medancic, did you have anything you wanted to add outside of what Mr. Riccardi testified?
No, I do not.
Okay, thank you. All right, we've heard from all sides here, so I'll open it up to the board for any questions, comments, or motion.
Madam Chair, I do have a question, Ms. Member Brown.
Go ahead.
On the agenda, there are different dates. So my question is there a history at this property with other violations from 2019, or was that a clerical error?
What two dates, can you call out the two dates, so then whoever did that might be able to give you some clarification on that?
On the agenda that I have, and this is, yeah, let's see. Yeah, October 7th, 2019 as the violation notice, and a filing date of November 12th, 2019. But in the testimony, they talked about 2021. So I'm asking if, is that a clerical error or is there history? And that's an old violation indicating history of problems here.
Madam Chair, I could speak to that. This is Liz.
Yeah, I think I got it, but go ahead, Liz. Yeah.
Yeah, that is a clerical order, error. The violation notice that we have in the file was issued December 27th, 2021. I apologize
Thank
for
you.
that.
Okay.
Is that all your questions, Ms. Brown?
Yes, ma'am.
All right. Any other board members with questions, or if not, I'll entertain a motion.
Chair, no further questions. I'll move to a motion. Given testimony that we've heard from Councilman Mooney, from the Westtown CDC representative, and from Mr. Riccardi, all in support of upholding the violation notice. I move that we do just that and uphold the violation notice and deny the appeal.
Thank you. Can I have a second?
Second, Ms. Barnes.
Ms. Barnes with the second. Go ahead, call the roll, please.
Thank you, Madam Chair. Ms. Brown?
Yes, to deny the appeal.
Ms. Barnes?
Ms. Barnes, yes.
Ms. Bath?
Yes.
Yes, I heard her.
Oh, okay.
A little froggy today.
Calendar 22-012 is denied. It'll be ratified next week, and we will send the appellant a letter.
Okay, thank you.
Yeah.
Thank you.
All right, I do not see any other council people, so we will move back to calendar number 22-010. This is at 1966 East 66th Street. The Cleveland Foundation owner proposes to erect a 196-foot by 68-foot carport with solar panels in a MMUD-2 zoning district. The owner appeals for relief from the strict application of the Cleveland Codified Ordinances as stated in the agenda and the public record, of which there is one. And to that, Ms. Brown for the oath.
Thank you. I'm swearing in all who are present for this case. Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth? Please raise your hand, reply, I do, then state your name and your address, please.
Miles Murray, 8308 Lake Avenue, Cleveland, Ohio.
Roseanne Potter. I do. Roseanne Potter, 1300 Bridget Lane, Twinsburg, Ohio.
I do. Laura Reese, 3142 Prospect Avenue, Cleveland, Ohio.
I do. Rob Martins, 1050 East 9th Street, Cleveland, Ohio.
I do. Terry Rivera, 6923 Father Caruso Drive, Cleveland, Ohio.
I do Richard Varga, 3808 Clinton Avenue, Cleveland, Ohio.
I do Kim Scott, City Planning, 601 Lakeside Avenue, room 501.
Madam Chair.
Okay, thank you. History of the property, please.
Thank you, Madam Chair. This property was originally zoned general retail in 1929. In 2006, it was changed to the current zoning of Midtown Mixed Use District Number 2. And the most important information on this property is that there are no variances on file. And then in 2012, a permit was issued to demolish a 2-story structure on the site. And that's all that I have, Madam Chair.
Thank you. Legal standard.
Thank you, Madam Chair, members of the board. Appellant is requesting a use variance. To obtain the use variance, appellant must prove that denying the request will result in an unnecessary hardship particular to the property, such there will be no economically feasible use of the property without the variance, will deprive the appellant of substantial property rights, and that granting the variance will not be contrary to the purpose and intent of the zoning code.
Thank you. Who's going to be the spokesperson for this case?
I will, Madam Chair, I'll kick it off and then hand it over to our design construction team, if you don't mind.
And you are?
I am Roseanne Potter, Senior
Okay.
Vice President and Chief Financial Officer of the Cleveland Foundation.
Okay, go ahead, Ms. Potter.
Thank you very much. Well, good morning, Madam Chair and everyone else on the board. We want to thank you today for hearing our appeal. We wanted to just introduce you today to the fact that we are, as I'm sure you may very well know, building our new headquarters on the corner of East 66th and Euclid. We have here today with us our architect from Vocon, our owner's rep, Terry Rivera, and we also have Better Together Solar, who are the designers and construction for a solar canopy. The lot that we're talking about that's in question is actually designed to be an outdoor parking lot of 101 spaces that was previously presented to the committee and approved along with our headquarters design. The designs that we have show here it's a solar energy panel constructed as a canopy. It would sit in the middle of the parking lot. It's very, very similar to the exact same type of solar canopy that is used at Rainbow UH Babies, which is just a couple of blocks down the street on Euclid in their parking facility. The energy that'll be produced from this will help to achieve a LEED Gold status for the Cleveland Foundation's building in using the solar energy versus using more other types of energy. And so we're here today to try to understand, what needs to be done in order to go forward with the construction of this canopy, which, we thought was previously approved in the parking lot permit.
Okay, so you're handing it off to someone else now, right?
Yeah, so I'll hand it over to Laura Reese, our Vocon architect at this moment.
Okay.
Good morning, all of you. Roseanne, as Roseanne explained, the permit that was established for this project and the design review and the planning review process included the solar canopy and the parking lot as part of the project for the new headquarters building. And the parking lot in particular has been permitted through the entire process. The assumption was that it had been previously approved through the planning process and through the design review process for the canopy itself. At this time, of course, we are submitting for the solar canopy portion of the project, but it had been included in previous submissions. So, Roseanne, are we going to go to Miles from here?
Yes, if you don't mind, we'd like to introduce the Better Together Solar team. Miles,
Yeah, Mr. Murray, go ahead.
Hi, excuse my appearance. I'm recovering from a recent surgery. In going through the documentation, and thank you all again for your time. But in going through the documentation, this is zoned in an MMUD. And you know, our perspective is that the use of this property has not changed. This was permitted as a parking garage and off-street parking accessory for the new construction that's happening across the street. This is, you know, auxiliary parking, employee parking, visitor parking for the facility. The canopy that we're proposing is simply making use of, you know, land that otherwise would be sitting there as only parking, but trying to take that and turn it into electricity, renewable energy that can be used over at the Cleveland Foundation main headquarters. This structure is, you know, similar to other projects that we've got around town, from the First Unitarian Church in Shaker Heights to the aforementioned Rainbow Women's and Babies Center, to the historic renovation project over at the corner of West 25th and Detroit. We received the notice of non-compliance and initiated this because we simply think that this use has already been permitted in the permit. The use has been established by previous permits as being an accessory off-street parking permit, and that this is simply an additional utility being provided on the site.
Thank you. Is that it from your team, Ms. Potter?
Yes, we'd be glad to answer any questions that the team might have.
Okay.
Also happy to go through the slides. There's also an attached video document that kind of gives a 3D perspective on what we're looking at here so that you can visualize it better, if that is available.
Reese, do we have that?
No, I never received that.
Okay, we submitted those documents on, was it Monday, I believe?
Are there any paper renderings right now, Maurice, that has it? I mean, if they don't have, I mean, it's not, you know, necessary.
This is, I have what was submitted with the application.
Okay.
I just don't have a video.
Okay, so on Monday, we sent it to Elizabeth, and that was because previously we had attempted to send it to Cassandra, and it got kicked back. We didn't have, the email was not listed in the notice for where to submit these to. So if I can send that now, I can send that now, but you know, it's kind of my perspective that this use case was permitted, and you know, this carport was even suggested and called out on previous plan sets.
I'll go ahead and check that email, Maurice. Could you, sir, could you tell me which, through the chair, sir, can you tell me which person it would have been coming from?
It would have been coming from me, MYLES, and then the @ symbol BT, like Bravo Tango .solar, SOLAR. There is no .com, just miles with a Y at BT.solar.
Okay, we'll hear testimony from others while Liz is trying to find that. Mr. Martins, you sworn in. Is there something you want to say?
No, I think Miles has covered it very effectively. The notice of violation was received in response to our filing a building permit for the solar canopy. And was a surprise to us again, because we thought it was already, a permissible use and zoning had been approved.
Okay, thank you. Ms. Riviera?
I have the video now. Just let me take 1 second and
Okay,
I'll show that for you.
go ahead. Riviera, did you have anything you wanted to add?
Yes, good morning, everyone, and thank you. Actually, I don't have anything to add to the presentation by Miles or Laura. I'm here to answer, things regarding schedule and those kinds of items, if those questions come up.
Okay, thank you. Mr. Varga?
Good morning. I also sent a letter of support from Midtown Cleveland. I'm the Vice President of Economic Development here at Midtown, expressing Midtown Cleveland's support for not only this variance, but also the Innovation District, the Cleveland Foundation's headquarter move, and everything we are trying to accomplish in the neighborhood. So if that hasn't been provided, I'm happy to send it again. It was sent on Friday.
Okay, thank you. Oh, it's Varga. I had Varga. I'm sorry. Okay, I had that wrong. Excuse me.
No problem.
All right. Is this the rendering right here, Maurice?
Yes, ma'am. And I might also point out we have Kim Scott here, the neighborhood planner.
I have Kim on the list. I just wanted to get this over.
That there's parking spaces around the perimeter of it and underneath it. There'll be ample lighting. There'll be blue lighting, emergency lighting there as well. There'll be cameras. The parking lot is, as previously requested, it's not shown on this diagram, surrounded by a decorative fence. That's only for the entire rendering, showing you the 3D dimensional aspect of what the canopy will look like.
All right, thank you. All right, Ms. Scott, City Planning.
Good morning, Madam Chair and board members. I just want to remind the board the purpose of the Midtown Mixed Use Districts and why it was established. So it was established over 15 years ago, and the regulations are established in order to permit and encourage an intensity and mix of development that supports and implements the development policies that have been established for this area by the City of Cleveland, Greater Cleveland Regional Transit Authority, and Midtown Cleveland, Inc. The intention in establishing this district in the development regulations is to permit specific uses at a development intensity and with an urban form in that manner. To encourage pedestrian-oriented mix of uses, including retail, residential, offices, and light industry, expands the available economic development options while strengthening the existing uses found in the Midtown District. It encourages compact land development pattern that increases resident and employment densities to support RTA's Euclid Corridor Transportation Project investment and facilitates usage to and from the Midtown area. D, to ensure that the new development and or redevelopment will occur in a unified manner consistent with the Midtown Cleveland, Inc. strategic plan as adopted by the City of Cleveland Planning Commission. And finally, to establish design criteria for new development or redevelopment to ensure that an aesthetically pleasing and pedestrian-friendly environment is provided. And that was established in 2005. So here we have zoning code that is going on 20 years old. And at the time that it was established, this area looked wildly different than it does now. This project represents a huge investment in the city, a commitment from this organization, the Cleveland Foundation, to bring their headquarters to this community. The parking facility, although it's on a different parcel, it is serving the Cleveland Foundation building for its visitors and staff. I don't find that there's any conflict in having a solar structure on the site. This did go through the Planning Commission process. It was approved in November of 2020, and City Planning enthusiastically supports the board to provide a variance on this project. So, thank you.
Madam Chair, can I just add just something? It's the MMUD, the mixed use Midtown mixed use district, is a little bit of a unique district in our zoning code, in that if one use is not specifically listed, it's not permitted, and that's why we're here today. And as Ms. Scott just stated very nicely, we of course enthusiastically support this, and that's why this was kind of a surprise, I think, to everybody that, you know, it was already through Planning Commission, already approved. We were actually surprised to see it until we realized it was the MMUD district that kicked this out. So.
All right, maybe it's time to look at that again for future reference. Thank you, Maurice. All right, I'll open it up to the board for any questions or comments.
Madam Chair, this is Ms. Faith. I just had a question. I believe Ms. Potter noted that this particular structure with the solar panels is part of the LEED certification. Is the LEED certification contingent on this? I just wanted to clarify that.
Yeah, we most likely would not receive a gold status. We would
Okay.
probably drop down to silver if we did not have the solar capability to produce this type of electricity. So we would drop
Yeah,
down.
solar is a very powerful investment tool if you're trying to get LEED points and you're trying to make it to the highest levels.
Right.
So in order to get past, you know, basic LEED, you really need to start considering how you're going to implement renewable energy on site. And the building footprint and the roof weren't enough for us to get the points that we needed. So we decided to, you know, this was kind of a workaround in order to say, you know, let's get all the points we can. We have this big parking lot across the street. You know, how do we implement this is going to be the largest solar canopy in the Cleveland area, I believe. You know, it's about twice as big as the one over at UH Midtown. I don't think that there's any others that are this size. It's, you know, 250 kilowatts. It's something to be really proud of. And it'll end up offsetting, you know, quite a bit of the electricity or most of it at the Cleveland Foundation headquarters there.
That's excellent. Thank you, Miles. I appreciate it. I'm not sure everyone understands LEED certification. And to achieve the highest level is something that will bring positive notoriety to the Cleveland Foundation and also to the city of Cleveland. So, Madam Chair, do any of my colleagues have any other questions? I guess not. Okay, so with that, I will move that we go ahead with given testimony from 2 city planners from the Midtown CDC and the explanation that we just had from the Cleveland Foundation and their agents. I move that we go ahead and approve this variance for calendar number 22-010.
Thank you. Can I have a second, please?
Second.
Second, Ms. Barnes. Go ahead, call the roll, Ms. Kukla.
Ms. Brown?
Yes.
Ms. Barnes?
Yes.
Ms. Vaith?
Yes.
Ms. Britt?
Yes.
Calendar 22-101 is granted. It'll be ratified next week, and we will send the appellant a letter.
Thank you so much. We appreciate your support.
All right, thank you. Good luck.
Bye-bye.
Looking forward to
Bye,
seeing
thank
this
you.
project come to completion.
So are we.
Yes.
All right.
Thank you all.
Thank you so much, everyone.
Thank you. Madam
Bye-bye.
Chair, we move along to calendar number 22-013. This is at 1327 West 102nd Street. Rising Time Investment LLC owner proposes to establish use as a three-family residence in a B1 two-family residential district. The owner appeals for relief from the strict application of the Cleveland Codified Ordinances as stated in the agenda and the public record, of which there are 4. And with that, to Ms. Brown for the oath.
I'm swearing in all who are present for this case. Do you swear or affirm that the testimony you are about to give is the whole truth and nothing but the truth? Please raise your hand, reply, I do. State your name and your address, please.
I do. Philip Serena, 4902 North Randall Drive, North Randall, Ohio, 44128.
And Yamili Quesada, Cleveland address 1327 West 102nd Street. And that's in Cleveland, Ohio, 44102.
I do. Charlene Rossi, Cleveland address 1334 and 1342 West 102nd Street.
Anyone else? Madam Chair?
Thank you. History of the property, please.
Thank you, Madam Chair. There's been no change in the zoning since 1929. In our Records Administration Office, I found that in 1916, the permit was issued to erect a 2.5-story dwelling. There are no variances on file, and in the more recent history, we found that in August of last year, a permit was issued to replace windows and repair rotted wood on the front porch. And that's all that I have.
Thank you. Legal standard, please.
Thank you, Madam Chair, members of the board. Appellant is requesting a use variance and area variances from the minimum lot size and off-street parking regulations of the zoning code. To obtain the use variance, appellant must prove that denying the request will result in an unnecessary hardship, particular to the property, such there will be no economically feasible use of the property without the variance, will deprive the appellant of substantial property rights, and that granting the variance will not be contrary to the purpose and intent of the zoning code. To obtain the area variances, appellant must prove that denying the request will create a practical difficulty not generally shared by other land or buildings in the same district, will deprive the appellant of substantial property rights, and the granting the variances will not be contrary to the purpose and intent of the zoning code.
Thank you. Who's going to be a spokesperson for this case?
Phil Serena.
Mr. Serena?
Yes,
You
ma'am.
are? Okay, go ahead.
I apologize. I could not get on the computer. I had to use the telephone. I'm the general contractor that the owners have hired to handle this case.
Just hold on a second. Ms. Kugler, do we have a letter from him or from the owner?
Checking the file now.
Go ahead, Mrs. Serena. If we don't have it, then we'll have to get it.
We do. I apologize to interrupt, but we do have a letter.
Okay, good. Okay, go ahead.
All right, the property has been used as a three-family ever since God knows when. It has 3 gas meters, 3 electric meters. It has front and back entrances to the 3rd floor for fire exit and entering, separate exit and entering. The plans that we turn in show that it was designed as a 3-family. There are other properties on the same street who have been used, who are three families, have been approved as three family. One of them just a few houses down. The Ohio code, as I understand it, if it has been used for 2 or more years in a particular use without causing immediate harm to or danger to any particular person or resident, is permitted to remain in that use. Since it has been used as a three family for continually in the past, we're just trying to make it legal. Apparently, for who knows what, probably somebody trying to avoid paying taxes or something. It was not legal before. We're
Madam
trying
Chair,
to make it legal.
I'm sorry for interrupting. Could I make a statement? I don't know what code the gentleman's talking about.
Yeah, me either.
The zoning code, this has never been a legal three family, and there's nothing in it about using it for 2 years. I mean, I'm not saying the board should deny the request. I'm just saying that the owner has no right to it as a matter of right. If in fact they met certain criteria such as off-street parking and a bigger lot size, the board could grant an area variance for this use. But since they don't, it needs to be use variance and the area variances for no off-street parking and smaller lot size. Just to clarify that. Like I said, I'm not saying the board shouldn't grant it, and certainly what it's been used for, the uses in the neighborhood are relevant. But there is no such code that gives you free reign after 2 years.
Thank you, Ms. Wagner. Mr. Shrina, was this house recently purchased by someone else and that's what triggered this to become a legal use, or I don't know, or Ms. Kukla, you know what happened here exactly?
It's rising time. The lady that was just introduced herself bought.
Yes, this is Yaneli. The property was purchased last year, and it was a 3. So meaning there was the upstairs unit, the 3rd floor was used and livable with heat, windows, and all the requirements to be to be used as a livable unit.
Okay, so you just purchased it last year, and you purchased it as is for a 3 family. Then what, you went to get your maybe rental application or something and realized that it was illegal?
No, we were not planning on renting it. We're fixing up the property. We're fixing up the
for
property.
yourself?
We're fixing up the property right now. Correct. And Phil is the contractor. That's why he submitted the paperwork.
Okay, I was just trying to figure out how it got triggered. Okay, thank you. Ms. Rossi, you wanted to speak?
Yes, hi. I have been a owner. My husband and I have a vested interest in this neighborhood now for 46 and 32 years respectively. We own 2 homes across the street from this particular home. I know the history of that home. Yeah, it has been used as an illegal third for many, many years. I'm standing in opposition to this appeal simply for the fact that you're already taking a congested residential area and adding approximately, because if this gets okayed, you're opening up a can of worms, because every 2 family in that area will apply for a 3rd floor variance. You'll be adding approximately 50 cars on my particular street on 102nd for parking. It'll be chaotic. You know, a lot of the homes, that operate with illegal 3 families. You know, that was the game all along. in the 70s especially, there was a lot of conversions. It didn't make it legal, but so, you know, I'm looking for from the standpoint of all the congestion and a chaotic situation from West Boulevard to West 117th. You'll have everybody and their brother putting in 3-family homes, and you're going to take a nice quiet area and make it crazy. So that's where I stand. Thank you.
Thank you, Ms. Rossi.
Madam Chair, can I ask,
oh, go ahead.
can I ask Ms. Rossi if she's related at all to the Mr. Drescher, whose email I have on the screen, that lives at 1327?
He lives at 1314.
I'm sorry, lives at 1314 West 102nd Street. So no relation? Okay.
I don't know who you're talking about now.
Okay, thank you. Just checking.
Okay.
Wanted to make sure this wasn't the same objections. So just if everybody would note that we do have another objection on the screen.
Okay.
And yes.
I'd just like to make an observation.
Oh, hold on one second. I just wanted to clarify, Ms. Rossi, that's why they're here at zoning appeals to get the third unit legalized. So we look at everything case by case. So I can't agree that just because if we do grant this today, that means that we're just going to get a whole bunch of third families all over the place. So I just want to clarify that you know, that will trigger you know, a zoning review, and that they would have to come back here. So just so you'll know that. And Mr. Serena, you wanted to say something else?
I just wanted to make an observation in relation to what the lady had just said. I was just commenting to I live in North Randall, and they had just recently built this huge Amazon thing at where it used to be the mall here. And I had made an observation to my wife just a couple of days ago that they've added thousands of cars and trucks by the boatload. And I haven't noticed any difference in the traffic pattern, which was amazing to me. I had expected to see, for me to go out to work in the morning, traffic jams, but I haven't noticed any difference whatsoever. So I just think that her argument there is not necessarily the case.
Okay, thank you. I'll open it up to the board for, before I do that, city planning, what's your position here?
Yeah, Madam Chair. Adam Davenport, our neighborhood planner, was on the call, but he had to jump off. He said that he used to live on this street, actually, and that he did note that there are a lot of triples already on this street. Of course, he didn't state whether they were actually legal triples or not. I guess my biggest issue would be the lack of detailed parking on the site plan. It looks from an aerial image that there might be a parking pad in the back, as you can see here. But that's not detailed on the plan, so we'd like to ask the applicant if there is actually parking, and if so, we would need a revised drawing indicating the parking.
Yes, Phil, if you can speak to that. Sorry,
what's there?
Yeah, go ahead.
What's there is a pad for a removed 3-car garage.
Okay, Madam Chair, we would request that a revised site plan be submitted detailing those 3 parking spaces, scaled drawing indicating those 3 parking spaces.
Okay, so with that, are you all in support, or?
Yeah, we have no objections if they provide the parking.
Okay, thank you. All right, now I'll open up to my board for any questions or comments.
I do, Madam Chair. Member Brown. 2 questions to the applicant. When you asked the question about use, the applicant responded that they are fixing the home up. I'd like to know for sale or to rent. And then the other comment that I have to city planning, you're asking for a drawing to show the parking spaces. I'd like to make sure that we're requiring, item 4, that it be paved and drained and graded, that all of that be fixed up. It's not clear from the aerial that it is.
Thank you. I definitely add that to my request.
And so the question to the applicant, you're fixing it up to do what with the property?
Yes, Yamili here. We're fixing up the property to sale.
Thank you.
Okay, any other questions, board?
Madam Chair, did we have any statement from the CDC or from the council person?
They're not here. I don't know if Liz, did you get any correspondence?
Let me check the file. I don't believe so.
Okay.
Nope, I don't.
All right.
And then just to clarify, quick question. So the conclusion is if we submit a revised plan to indicate that there is ample parking for 3 cars, which there is, this would be approved. Is that correct?
We haven't gotten to that point yet. We're saying if we do approve it, we will require certain things. So just hold on a sec.
Okay.
And paved and drained. And Madam Chair, I'm not sure if Ms. Rossi has her hand up again.
No, it's been up the whole time. All of them.
Oh, okay.
Yes, I do. Yes, I do.
Oh, Ms. Rossi, you want to speak again?
I just real quick here. I just want to let you know, I did contact Jenny's, the council person's office, and I guess she had a prior commitment today to join us. So I just wanted to let you know. Okay.
Thank you.
Okay. So do we have any other discussion, Madam Chair?
I don't think so. I think we can move to a motion.
Okay, great. So with testimony from the owner's contractor and from the owner, that this dwelling has had 3 gas units, 3 electrical meters, has been previously occupied as a triple, though unknown if it's legal or not, and in a neighborhood where other triples exist, as testified by proxy to Mr. Davenport. I think we can go ahead with conditional approval of this motion based on Mr. Rulin's request. It would be necessary that we have revised drawings submitted for the parking. Those drawings need to show that the parking area has been graded, that it is drained, and that it is properly paved. The drawings need to be to scale and submitted prior to our ratification, should the vote go in favor of approving this, this variance. So with that, Madam Chair, I move that we approve the variances per 22-103. And I guess I would just also comment to the residents that are in opposition that, as the chairwoman noted, we take every case one by one. And so any other cases would have to come before us and be ruled upon as well. So with that, Madam Chair, I move forward with the motion to approve.
You can have a second, please.
Second, Ms. Barnes.
Ms. Barnes with the second. Go ahead, call the roll, please, Ms. Kukla.
Ms. Brown,
Yes.
Ms. Barnes,
Yes.
Ms. Babe, Ms. Brett.
Yes.
Calendar 22-013 is granted conditionally. We will hold ratification until we receive that updated plan showing that the 3 parking spaces at the rear will be paved, graded, and drained, and the new site plan will be drawn to scale. Once we receive that, the case will be ratified the following Monday, and we will send the appellant a letter.
Okay, thank you, everyone. Moving on.
Thank
Ms.
you.
Stace.
Moving on to calendar number 22-014. This is at 1250 Riverbed Street. 1250 Riverbed Street LLC owners propose to establish use as a 70-unit apartment building located within a K5 limited retail business district and an urban form overlay district. The owner appeals for relief from the strict application of the Cleveland Codified Ordinances as stated in the agenda and the public record. Of note, number 2, section 341.02 states that approval from the City Planning Commission department is required. And with that, Ms. Brown for the oath.
I'm swearing in all who are present for this case. Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth? Please raise your hand, reply, I do. State your name and your address, please.
I do. Ron Tannenbaum, 16102 Chagrin Boulevard, Sugar Heights, Ohio.
Mr. Kelly, you're muted.
I do. Kevin Kelly, 950 Main Avenue, Cleveland, Ohio, 44113.
I do. Mike F., 2828 Euclid, Cleveland, Ohio, 44115.
Madam Chair.
Thank you. History of the property, please.
Thank you, Madam Chair. This property was originally zoned general industry in 1929. In 1992, it was changed to general retail business. And in 2019, it was changed to the current limited retail and urban form overlay. I apologize, that legislation was effective in January of 2020. I think the most pertinent information is that in calendar numbers, oh no, I apologize. The permits for the existing building indicate past use as a store, offices, and a warehouse. In calendar 81-185, this board granted an appeal to convert office and warehouse to use as art studios, contingent upon an off-street parking agreement. And then in calendar 07-168, and that was in October of 2007, variance was granted to change use from office to assembly, nightclub, and amusement. And that's all that I have that's relevant, Madam Chair.
Thank you. Legal standard, please.
Thank you, Madam Chair, members of the board. Appellant is requesting an area variance from the off-street parking regulations of the zoning code. To obtain the area variance, appellant must prove that denying the request will create a practical difficulty not generally shared by other land or buildings in the same district, will deprive the appellant of substantial property rights, and the granting the variance will not be contrary to the purpose and intent of the zoning code. And I would just remind the board that you cannot grant a variance from number 2, which states the approval of the planning commission is required. That may actually have already occurred or be in place after this hearing.
Thank you. Who's going to be the spokesperson for this case?
I believe Ron's going to get us started.
Yep.
Okay, Mr. Tannenbaum, go ahead.
Thank you. One thing, just in terms of number 2, we did get schematic approval on July 15th from the Flats Area District, as well as from the Planning Commission afterwards. After we meet with you, we hope to go back to the Design Review Council and Planning Commission to get final approvals for that. But the building itself is a 2-part building. Part 1 was built in 1912 and the second part was built in 1917. The current property site is 100% lot coverage from the building. So basically the building is built out to the full extent of the property line, and it is a contributing structure to the Cleveland Center National Historic District as well. There are going to be intended use of 70 apartments in this property in the renovation, and that would require, based on the urban overlay district, 18 spots to be provided on the site. Since the site is 100% built out, we would need to provide this on adjacent properties. This is a unique site in that it is flanked by Riverbed Street on one side and the viaduct on the other side. So the only adjacent property technically is the current townhouse use. We do have, my client does have a lease in place that we've presented to you that provides 18 spots, which is the required minimum to be commencing tomorrow, and an increase to a minimum of 30 spaces on January 1st of next year, which is the earliest we could need occupancy. As stated, it's currently a vacant building that has fallen into disrepair, and until a few years ago, the ground floor was used as a nightclub, and there was living up above in terms of lofts for artist lofts. As you can see, we believe the project will significantly improve the building and bring 70 upscale market rate residences to the area and retain the unique character of a building that we feel represents the history of this community. With that, we would request the variance be allowed. There are some slides that show the uses here, and then the elevations that we are choosing to maintain. There will be a rooftop amenity deck, and then the owner has also retained a lease on the underside of the viaduct to create a community space for the residents to have as an outdoor lounge, which we feel is the best use of this space that's directly adjacent and under the viaduct, and would allow people to pass through and walk from the leased space and in. You can see that on this rendering right here. In terms of the view under the viaduct, that's rendered out as a amenity space as well as this one. So residents would walk through that and achieve their parking directly adjacent.
Madam Chair, may I ask a question related to the leased parking space? Can you show us on the site plan the location? You just mentioned walking under the viaduct, so that piqued my question.
Madam Chair, I added it to this drawing here. It's the blue square, I believe, is the leased parking area.
Correct.
And then the blue outline is the actual building at 1250 Riverbed. Sorry, I didn't mean to interrupt, Mr. Tannenbaum.
No, that's fine. And the sort of empty space between the light blue building and that next green line is the viaduct. That's the amenity space that we would have the residents walk through, and then they could also walk on the public streets to gain entry from the other side of the building. As you're probably aware, there's a significant amount of parking on the other side of the viaduct to support the Nautica and Powerhouse, and the uses on that parking have, sort of few and far between where they're a heavy use, and Jacobs Group has generously given us a long-term lease on those spaces to allow for these residents to occur.
Madam Chair, this is Liz.
Yes.
If we could ask the appellant to send us a copy of that parking lease agreement. I do not see one in our file.
It was emailed to you, and I believe it was just shown on the screen as well. It's after the renderings.
Yeah.
Okay, great.
Yes,
Yeah,
I have the email.
Yeah, I thought I saw it on the screen. Okay.
It's right there.
Yeah.
Thank you.
Okay, Mr. Tannenbaum, anyone else from your team want to speak? Mr. Kelly?
Thank you. I just want to let you know that I've spoken with Councilman McCormick, who is in full support of this project. It's a great opportunity to take an otherwise vacant property and make something great out of it. The lease that has been signed satisfies a requirement that's being requested, and as Ron previously stated, we have schematic approval from Planning Commission and plan to go back for full approval after we get through today.
Thank you. Mr. App?
No, ma'am, thank you.
There's nothing else to add? Okay, as a former resident of the West Bank of the Flats, I'm glad to see something's happening with this building, so that's good to see. I'll open it up to the board for any questions or comments.
Madam Chair, this is Liz. Sorry to interrupt. I do have a letter of opposition from a resident at 1237 Washington Avenue, Unit 412. He's writing the letter to object to 1250 Riverbed Street for the appeals of the relief of the specific sections mentioned. As a longtime resident of this area, he stated that with 100% that there is not enough street parking as it is for residents of the building. Approximately 25% of his building has to park on Elm Street, Washington Avenue, and Center Street because the condominium units do not have the garage parking spaces needed. These available street parking spaces become very difficult to obtain on days when there are events happening nearby in the area, such as concerts at Jacobs Pavilion. In addition, parking in the area has become considerably worse with the addition of the tank building in the flats, acting as an event center and a wedding venue. Oftentimes, the guests choose not to use the tank building parking lots or valet parking and instead park on the streets mentioned above, which leaves residents in his building with no available street parking. This is especially troublesome during the winter. Let me see. The proposal would only exacerbate the parking issue. And there's not enough street parking in the area. Elm and Washington specifically cannot handle 18, 25, or even 30 cars to park in the area on any given day with the addition of this apartment building. He strongly opposes this variance. Thank you, Madam Chair.
Thank you. Board.
Madam Chair, we have Mr. Kelly with his hand raised again and Mr. Tannenbaum with his hand raised again.
All right, Mr. Kelly.
Thank you very much. In response to the letter, the spaces that are being leased, that are being provided by Jacobs are more than ample to deal with whatever congestion may be caused by this. But in addition, there's also, I believe, 15 or 18 street parking spaces that are not used right now or not plowed right in front of the building on the river side of it. So I believe that the lease, along with the available street parking, yeah, right. If you go back one slide, go back one slide.
I'm sorry, which one?
Go back one.
Go back.
Yeah.
The aerial.
Yeah. So there are street parkings right along Riverbed Street that are unused and it's unplowed, but there's about, I believe it's 15 to 18, maybe Ron knows exactly, but I do believe the lease along with those spaces more than will mitigate the congestion for the on-street parking for the current residents.
Yes, I would like to second what Kevin Kelly has just said and add that it was a very similar concern in terms of our discussion to create a long-term lease on private property that isn't going to overburden the streets even further. And that's why, even though the code does require 18 spaces, you can see from the lease that our owner has chosen to actually lease 30 spaces. So we are actually going above and beyond the codified requirements of this urban overlay district and obtaining 30 leased spots with the direct intent of not further exacerbating the issue of street parking. In addition to that, we were in discussions with former Chief Rybka in terms of creating additional parking along the street there on Riverbed, which could further provide parking to the community and to the building itself. But that has not been resolved yet, and I don't want to add that in to the mix yet, besides to say that that's part of the rebuttal to that argument, which is that we are currently working with the city to look at traffic patterns and potentially provide additional street parking where we see them fit between our building and the community park directly across the street. But again, just to reiterate, 30 spaces that would be on private property, I think should alleviate the concern of that resident.
All right, thank you. Maurice, I didn't see, is anyone from city planning here, or is that you?
No, just me. Yes, city planning is very happy to see this building renovated and brought back to life. It is a substantial building in the Flats. It's been there for a very long time. I've been working with the Flats ever since I started my career at city planning here, and that building has been in use almost the whole time in various stages. A lot of residential in there. I don't know that we would have supported it without having some parking, and they have gone way above and beyond and provided 30 spots over in the Nautica lot where they only really needed 18. And other than on really, really busy nights where there may be an event at Nautica Stage, that lot is generally not anywhere near capacity. So yes, we fully support this project, as did the Planning Commission approve it, give them schematic approval.
We won't ask how long you've been at city planning, Maurice, so you can keep that secret.
33.
All right. I will open it up to the board for any questions, comments, or mention.
Madam Chair, I just, we kind of have been talking a lot about the parking, but I just wanted to reiterate, we have a contract already in place for 18 spaces. And I believe the start date for the second contract for parking, if I remember correctly from Mr. Tannenbaum's statement, starts in January of 23. Is that correct? Do we have a copy of that contract?
That's in the same contract language that you have on the screen.
In the same one. Great. Okay, we got that covered then. All right. Is there any further discussion then? All right. Madam Chair, I'll take it to a motion. Calendar number 22-014. Given testimony from Mr. Kelly, from Mr. Tannenbaum, the support of city planning on this, and Maurice has given away his age there with his tenure at the city. We know that they have already had some review from the design review board. And so number 2, city planning approval will be pending. Do we feel like we need to make that conditional on approval, or can we just go ahead and move to approve this?
So just go ahead. Yeah.
Okay, great. So with that in mind, I move that we go ahead and approve variances for the variance for calendar number 22-014.
Thank you. Can I have a second?
Thank you, Ms. Barnes.
Ms. Barnes, second. Go ahead, call the roll, please, Ms. Kukla.
Ms. Brown?
Yes.
Ms. Barnes?
Yes.
Ms. Fave?
Yes.
Ms. Britt?
Yes.
Calendar 22-014 is granted. It'll be ratified next week, and we will send the appellant a letter.
Thank you all very much and great to see you.
Thank you.
Thank you. Take care, Mr.
See you
Kelly.
too. Thank you.
Good to see you.
Great to see you.
All right, moving on then, calendar number 22-020. This is at 4636 Oakley Avenue. Mitsa Paria, sorry if I've mispronounced that, owner proposes to erect a second-story addition and an attached garage to a single-family residence in a B1 two-family residential district. The owner appeals for relief from the strict application of the Cleveland Codified Ordinances as stated in the agenda and the public record, of which there are 6. To Ms. Brown for the oath.
I am swearing in all who are present for this case. Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth? Please raise your hand. Reply, I do. Then state your name and address, please.
I guess I'll go first. My name is Greg Noeth, Noeth. I'm the architect. I live at 1790 Saratoga, Saratoga Avenue, Cleveland 44109.
My name is Mitzi Perea. I'm the owner at 4636 Oakley Avenue, Cleveland, Ohio 44102.
Anyone else? Madam Chair?
Thank you. History of the property, please.
Thank you, Madam Chair. There has been no change in the zoning here since 1929. There were no records in our Records Administration Office. There were no variances on file here, and I only found in the more recent history that in 1998, a permit was issued to re-roof the property. And then in 2020, a permit was issued to board 9 windows and 2 doors. And that's all that I have, Madam Chair.
Thank you. Legal standard, please.
Thank you, Madam Chair, members of the board. Appellant is requesting area variances from the side street, corner lot setback, front yard setback, rear yard, distance, side yard, and maximum gross floor area regulations of the zoning code. To obtain the area variances, appellant must prove that denying the request will create a practical difficulty not generally shared by other land or buildings in the same district, will deprive the appellant of substantial property rights, and that granting the variances will not be contrary to the purpose and intent of the zoning code.
All right. Who will be the spokesperson for this case?
I guess I will. I'm Greg Noah, the architect.
All right, Mr. Knowles, go ahead.
Well, one of the problems we have is we're going to add a second floor to the existing first floor house and make a livable bedroom units. And that involves why we're approaching right along the street setback, that the existing home right now borders right up to the street on the first floor. So that's one of our problems. The old layout of the house actually had a garage that went in the back area. It came in off of West 14th. Was that West 14th? I can't read. West 47th Street?
West 47th.
Yes, off of West 47th across the backyard into a garage. And somebody along the way put it what is now the existing driveway to the east side of the house. And we're going to keep that driveway, but redirect the garage to face that new driveway to create a backyard along West 47th Street from the back of the house. The owner requested to put a living unit above the garage for additional space, and that led to why we're at such a large amount of floor area. And that's basically what we're doing. There's another home similar to this on Oakley across the street from us on the south side that did similar, adding a second story and a 2-story garage. And that's what we're matching.
Okay, and the homeowner, do you want to add anything?
No, just trying to see if I can get this approved so we can move forward and try to fix the home and just give it a better improvement on that street. There's only about 4 houses on that street.
Will this be your house?
Yes, ma'am.
Okay. All right, city planning?
Yes, Madam Chair, I wanted to ask Ms. Wagner if she would chime in. Because this is an existing condition, I'm sorry, talking about the front yard setback, as you know, that can be problematic for the board to grant.
Yes.
This is actually an existing condition, so I believe the board has the authority to grant this?
Yes, that is correct. I think myself and Maurice and the rest of the staff looked at this, and it would fall in the category of a expansion of a non-conforming use, which can be provided if a variance is granted. Obviously, if they had tried to extend the second floor so that it was less code conforming in the front yard, that would not be allowed. But in this case, it's the same distance that it exists right now.
Very good. That's kind of what I interpreted, why I didn't make it a big deal that I normally do. But
Just wanted to clarify because I know they can be a big deal.
Appreciate it.
And also, of course, the 0-foot setback on the side yard, which is over there on West 47th, is an existing condition, as you can see. And if you look even on my pictures, you can see that the house next door also has the exact same condition. So it's a common condition in that neighborhood. It was built years ago in just a very dense neighborhood. And for those reasons, we have no objection to this application.
Thank you, Maurice. All right, I'll open up to the board.
Unless any of my colleagues have questions, I'll move forward. Okay.
We do have, Madam Chair, I don't know if anybody noticed Gabriel Rivera has his hand raised.
Who is it?
I don't know if he was, sir, did you want to comment on this case?
I think he was on the last couple of cases.
Yeah, I think he was in the last one. That's what it probably was.
Yeah.
Yeah, I can't hear him. Okay. Just don't want to miss anybody.
Thank you.
Of you to be so alert, Maurice. All right. So with that, since we have no other comments, Madam Chair, given the testimony from Mr. Noeth, the architect, the homeowner, our statement from Ms. Wagner on the legal technicalities, and also the support of city planning on this, we know that this is a very dense neighborhood with very minimal setbacks all the way around. So we will go ahead and I move that we go ahead and approve these variances for this project that looks like a very nice home. So
thank you.
We'd like to have this move forward.
Thank you. Can I have a second, please?
Member Brown, I second.
Brown, second. Go ahead, call the roll, Ms. Kukla.
Ms. Barnes,
Yes.
Ms. Brown,
Yes.
Ms. Vaith,
Yes.
Ms. Britt.
Yes.
Calendar 22-020 is granted. It will be ratified next week and we will send you a letter.
Thank you.
Thank you, guys.
All right. Good luck with your house.
Good luck
Thank
with
you
it.
so much. Thank you.
Looks
Bye-bye.
very nice.
Thank you. God bless you guys. Bye.
Madam Chair and Ms. Kukla, somehow
Oh my God, that is the best news
I seem to be
ever.
missing the
Hi.
first
How
slide
are
for
you?
East 65th
Put
Street.
my mask on as well.
Mitzi, you gotta mute your
Oh,
phone, honey. We can
I
still
do
hear you.
apologize.
You're still live.
Okay.
There we go.
There you go. All right.
She was all excited.
Ms. Faith, do you have the agenda in front of you? Can you read it from the agenda?
I can read it from the agenda. Absolutely.
Thank you. I don't know how that happened.
Not a problem, Maurice. Okay, so calendar number 21-181 was postponed from January 24th, 2022. This is at 3733 East 65th Street. Rand Romano, owner, proposes to establish use as 7 residential units and 3 commercial units in a B1 local retail business district. The owner appeals for relief from the strict application of the Cleveland Codified Ordinances as stated in the agenda and the public record. Of note is number 5, section 352.04, which states that a landscape plan is required. And the second postponement of this case was made at the request of the city planner to allow time for design review to take place. And the first postponement of this case was made at the request of the councilperson to allow time for community review. We trust that all those things have happened and we're here today to hear this case. And with that, to Ms. Brown for the oath.
I am swearing in all who are present for this case. Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth? Please raise your hand, reply, I do, state your name and your address, please.
Nicole Calhoun, I do.
601 Lakeside, room 501, Cleveland, Ohio, 44114.
I do. Marilyn Moshinsky, Slavic Village Development, 5620 Broadway Avenue, 44127.
I do. Ron Romano, 32 Mapledale Avenue, Bedford.
I do. Angela Mumford, 1889 East 75th Street, Cleveland, Ohio.
Anyone else? Okay, Madam Chair.
Thank you. History of the property, please. Or did we get the history before? I can't remember. They just kept getting postponed, right? Yeah.
No.
Yeah, we did not.
Okay.
The property was originally zoned general retail in 1929. In 2007, it was changed to local retail business. I found in the Records Administration Office that in 1914, a permit was issued to erect a two-story stores and tenement building. There were no variances on file for this address. And then in the more recent history in our Acela system, in 2014, a permit was issued to board up one standard size window in a general retail zoning district with a walk-up. It was known as a walk-up apartments at that time. Oh, it was retail. I'm sorry, I apologize. It was retail and walk-up apartments. In 2017, a permit was issued or a condemnation notice was issued for the main structure. And then later in 2017, we see a permit was issued to repair interior exterior. And this stated that there were windows and gutters and downspouts that were either installed or fixed. In 2019, a certificate of disclosure was issued stating that the authorized use of the property was as storefront and residential units. Then in January of 2020, a condemnation notice was issued again for the structure. And then in September of 2021, a permit was issued to board up one standard size door on the property. And that's all that I have, Madam Chair.
Thank you. Legal standard, please.
Thank you, Madam Chair, members of the board. Appellant is requesting area variances from the off-street parking, screening, and landscaping requirements of the zoning code. To obtain the area variances, appellant must prove that denying the request will create a practical difficulty not generally shared by other land or buildings in the same district, will deprive the appellant of substantial property rights, and that granting the variances will not be contrary to the purpose and intent of the zoning code.
Okay, thank you. Who's going to be a spokesperson for this case?
I am Angela.
Okay, Angela, go ahead.
Okay, so with this building, we're going to rehab the 7 units, and we're going to make the storefront into a coffee shop in the neighborhood. And then also, if we could, we were going to add some parking spaces. So we're going to share the parking with the building owner, with the other building owner that's right behind us. We're going to add lighting. We already got approval from him for that. And then we're also going to add lighting in the back for the parking and around the building. And then I don't know if you see I sent over some updated slides. See if they can scroll down some more. More.
That's the last slide. That's all I have.
That's all you have? Well, we have some updated slides, and then in those slides, we have the additional parking spots, and then we also have the shutters that are going to be raised and added to the hinges, just like you guys requested, so that they can match the window height. And then we're going to remove the bushes, the hedges, as well. And that is all that we have.
Madam Chair, I did find that that email, and I'm sending it over to Mr. Rowlands right now.
Madam Chair, may I ask, is the building vacant or occupied now?
Oh, the building is currently vacant.
One more question, Madam Chair. And how long has Mr. Romano owned the building?
He's owned the building for about 2 years. Just waiting on those other slides to come up.
Ms. Kukla, can you resend that? You sent the email as an attachment? I can't open that. I just need the attachment. Thank you.
That seems to be the only email that is coming up.
Okay, let me see. Let me see if I can resend the presentation to you.
Yeah, Madam Chair, I have no additional slides in the email that
Okay.
I don't know if we ever received any.
And while that's going on, because we didn't have it on the screen, Maurice, can you just give me or Miss Faith just a quick summary of what variances they're asking for?
Oh, let me see if I can bring
Chair,
that up on screen for you.
Okay.
Go ahead, Alana. I'll try to bring them up on screen too.
All right. Number one is section number 349.04 that states that 13 parking spaces are required and 9 are being proposed. Number two states that accessory off-street parking driveways and maneuvering areas shall be properly graded for drainage so that all water is drained within the lot in the parking spaces. And the driveway shall be used to provide accessibility to accessory off-street parking spaces, shall be located and arranged to minimize traffic congestion. The proposed driveway use is not subject to parcel nor in the same ownership. Number three states that where 5 or more accessory off-street parking spaces are provided and are located on a lot that is adjacent to a residential district or that adjoins a building with dwelling units, such parking spaces shall be screened from all adjoining lots in the residential district by an opaque wall, a uniformly painted fence of fire-resistant material, or a strip of land with at least 4 feet wide, densely planted shrubs that form a dense screen year-round. Let's see. Number 4 states that a 10-foot wide landscape strip is required, and number 5 states that a landscape plan is required. So basically, we're looking at variances for parking and the requisite landscape strips, Madam Chair.
Yes, thank you. I needed some context here. All right, great.
Yep.
Madam Chair, I found that email. I hope that Mr. Rowlands has it now.
Okay, thank you. Okay, so if you scroll down to the, well, I'll wait till it comes up.
1 second. Yep, working on it.
Okay, thank you. Okay, so if you see the additional parking, so for the plans, we are going to have some more updated plans with the additional parking, but you see there are going to be 9 more shared spots with the building right next to it. Our architect, he recently passed away, so we have to get another architect to redo the plans for you guys. And then the green lines are the connector walks. Oh, I'm
Ms.
sorry. Go
Mumford,
ahead.
so the parking that's directly adjacent to the existing building is the one that you have, and then the one across from like the green line there are the additional spaces you're talking about?
Yes, so to the right, those are the additional
Yeah.
spaces.
Okay, all right, continue.
And then you see the connector walks, and those are connecting to each opening in the building. And those are going to be the pathways for them to walk and gain access to the building. Go down to the next slide. And then there was also for the windows, well, we had a motion and conditions, and on that motion and conditions, one of the issues where they wanted us to specify the windows that were going to be replaced. But we're not going to replace any windows. We're just going to reglaze the cracked windows that are already there because the windows are aluminum. So we're just going to repaint those windows that are already there.
Well, windows aren't part of your variances, so you don't have to worry about us reviewing that.
Okay. Okay. Let me see here. And then we have the shutters. Well, I see that wasn't a part of the variances either. But so the parking was the biggest issue, and we're going to have that, and that's going to be shared. So we're going to have the parking and the lighting plan. So we're going to have about 18 spaces.
So the variances is written up now is that you currently have 13, and that's the ones that are adjacent to the building. But you only have 9 there, and then you're proposing those extra ones that you're going to share with the other neighbor, correct?
Correct.
Madam Chair, to perhaps Ms. Kukla or the appellant, do we have the lease agreement for those additional parking spaces? Did we
Yes.
receive a copy of that? Did I hear a yes?
Let me check the file. I don't remember receiving one, but I will double check.
No, we can make that a condition.
Right. And I see we had a picture of we had a rendering of the hedge to fulfill that requirement, correct?
Screening. Mm-hmm.
Yep. Okay.
Madam Chair, I do want to point out that we also have Nicole, our neighborhood planner, Nicole Calhoun, who would like to comment, and we also have Marilyn Masinski from Slavic Village.
Yeah. I just wanted to make sure that Ms. Mumford was done with her presentation before I called on anyone else.
Okay. And so we do have the leasing agreement from the neighbor, but I can go ahead and I can send that over to you guys. I just have to find it. So we do have that.
Okay, well, you can finish your presentation, and then while others are talking, you can try to send that over.
Okay. Well, yeah, no, we're done with the presentation. So we're gonna have the 7 units and then additional parking, and we're gonna do a storefront with the coffee shop in the neighborhood. So a coffee shop with coffee and then kind of like a cafe. So, espressos, wraps, and things like that.
All right. Okay, we'll go with the you said we have the CDC here. Is that Maryland?
Yes, it is. Yes.
Yes, ma'am.
Go ahead.
Good morning, everyone. This is Marilyn Moshinsky from Slavic Village Development. I'm representing myself, our CDC, and also Councilwoman Marr. I want to let you know that we have yet to really get these, as you can see, the presentation that was given today is more of a design review presentation than a variance for parking. This is yet to go through, this is a design review district and has yet to receive final approval for the design that was presented to us. And in fact, we just heard from Ms. Mumford on February 15th. Before that, the entire time when we were working with another person that was project person for this, her name was Alexandria Kudekis. And last conversation we had with her was back in August 24th. That's when we received some of these drawings again. They had tried to go through, and Ms. Calhoun will explain the timeline on design review. But as of November 23rd of 2021, I received a voicemail message from Ms. Kudekis saying she was no longer involved in this project and that she and her partners were not helping Mr. Romano anymore. And from November of 2021, we did not receive anything till February 15th to even try to put it back onto design review. I do know that our conversation with Mr. Romano, when I've asked him about maintenance issues on the parking lot of overgrown grass, garbage, broken windows, he told me he wasn't planning on doing anything to the property to take care of this. Also, he has not paid his property taxes since he's purchased the building in November 21st of 2019. With all of those conditions, we are asking that you do not approve this variance until it has gone through and reviewed. And we've not had a community meeting because we just met Ms. Mumford on 2/15, or she was introduced via email to us on February 15th. So the councilwoman, the CDC, and the residents in that area have not met with anybody to look this over. And also to do a design review, we've not had anything through that. So we are asking for a non-approval of this variance and hoping that we can get this back onto track and come back to another one for you. Thank you.
Well, technically, we can't not approve it and then you have them come back. If anything, we have to, postpone the case, but we can't not approve it and then come back. So I'll go ahead and hear from Ms. Calhoun.
I can say something, please?
Hold on 1 second. I'm gonna hear from Ms. Calhoun, then I'll go to you, Mr. Romano.
Okay, thank you.
Thank you, Madam Chair. As requested, we did try to meet with him on the 26th of January, at which time I tried to explain to Mr. Romano that building, Board of Zoning and Design Review are two separate entities. And I tried to explain to him about the procedures that was thoroughly explained by his contact person who actually submitted the application to Design Review. There are 3 levels, as you well know, for design review for the actual East Design Review, and then there are 3 levels for Planning Commission. He did not allow me to finish the communication. He began to get very belligerent, and the meeting had to be abruptly stopped. He began yelling and in a threatening manner began to walk towards me and Marilyn, at which time I pulled out my camera and stated to him that I would be recording him. He then decided to calm down and left. At which time I came back to City Hall, went straight to Liz to report the meeting, and found out that he had withdrawn all his items. So I have tried several times to explain to him that these are 2 separate meetings, and I have worked with Alexandria since 2019 to try to get her presentation to the point to where it can be approved. The new set of drawings, like Marilyn has said, are new to me. And so I asked that this be postponed because I couldn't even sign off on it until it goes through design review. We actually even work with them to begin to split the permits up so they can start the work on the inside and go through design review on the outside. I've tried several different attempts, so I'm here if you have any questions, Madam Chair.
Thank you. Okay, Mr. Romano, go ahead.
Good morning. The first thing, the last 2 years, everything Marlin called to the city or text me the email, Ron, the glass is broken in the front of the windows of the shop. You need to cover with plywood. I send my guys with me together and we cover the windows. You tell me the bushing is not good, you need to clean the snow. This is what I do the last 2 years because this building is very important to me. It's the front of the Slavic village and everything she tell me, cut the bushing, cut the grass, and it's okay they don't approve it, but the time the process to approve it, I fix everything she tell me to clean the snow, to cover the glass window because people use drugs inside the building. And I tell her about this. And after this, after a few days, cut the bushing. I go to buy the bushing. After this, go to cut the grass. I go to cut the grass. She texts me another email. Clean around the building. I clean around the building. And I do everything to approve this building for me. I'm ready with the money. I want to do everything by the code. And it's very important because this is the front of the neighborhood. So I don't want to sell it. I want to fix it and keep it. I feel it like it's something in my life. So everything they tell me to do, I do it. And I'm not laugh for anyone in the face. I respect everyone. And I come to this building several times to the city because I want it's going to be happened. So every time she tell me the last 2 years to fix, I do it the same day or the next day. To cut the grass, the bushing, the plywood, to clean the snow. They not approve it, but everything she tell me, I do it because I want to feel good with this job and she feel like I do something to the building. But all the time the building, they broke the building and use the drug inside, I not feel good with this. That's it.
That's it? Okay, thank you, Mr. Romano. Ms. Kukla, you have your hand up?
Yes, Madam Chair, just for clarification, again, for the new members here on the board, there are, as Ms. Calhoun stated, these are two separate approvals. If the board approves the variances today, they would still have to go through the design review process. And just one thing that over the years that we see often when there is a use issue, the appellant does not want to spend the money to get these extensive drawings if they don't know whether or not they're going to get the variances. So there is often, I hear that, and I don't know if it is in this case, but we do hear that often. So sometimes it's a catch 22 in these cases. Just a thought, Madam Chair.
Thank you. Ms. Mumford?
Yes, so so if it does get approved today, we will go through the proper process with the design committee. And I'm going to be working really close with you guys, just to let you guys know. So it's not going to be a disconnect. So hopefully after the meeting today, we can go ahead and link up and talk about the next steps for the design committee.
Thank you. Marilyn, do you have your hand up?
I do, thank you. Just to talk about the variance a little bit more. I understand that people are nervous about not getting a variance accepted. I can tell you, I've been working here for, in the CDC world and working with different businesses and stuff like that. And as long as we have a good conversation and communication, I've never seen a variance not being put through that. When I'm working with the council person and the CDC and the community have always been supportive. We've had a bad communication here, and I really would like to see this postponed and continue to work with design review before a variance, because I just know the importance of this variance and how it stays on the property for a long period of time. So I'm asking the committee to please postpone this until we can actually get this through the design review and through a proper property. We all agree that this is an important property. This property has history that I could talk about for hours because I'm familiar with the property. And it also has bad history because it's been left vacant for over 5 years. I've been at Slavic Village for 8 years, and it's been over 8 years that it's been vacant. So seeing this, renovated would be the only best thing for it. But I think until we can get some better line of communication, I'm asking for a postponement. And I know that's what the councilwoman would also want also.
All right, thank you. I think we've heard from everyone. I'll open it up to my board.
Madam Chair, this is Liz. We do have a letter from Councilwoman Moore. She does say as Ms. Mujinski stated, that she would like to see them go through that process.
Thank you. Board questions, comments, motions?
Madam Chair, just formulating thoughts here. I'm wondering if postponement is the correct action at this point, or withdrawal and a resubmittal is really in order here. I'm just trying to think through what the best course of action is, if anyone has any comments.
Well, I don't think he's changing his project, so I don't think a withdrawal is appropriate.
All right.
Well, there's a new design team that he's working with.
Right.
Yeah, but the project isn't changing itself, though. I mean, he's doing the same exact thing. He just has new people doing the exact same thing. So I don't think requiring him to withdraw is going to change the outcome of the project.
Okay.
Madam Chair, through the chairwoman, this is Liz. Has the appellant gone through section by section to address the items? Section 2 states that it's required that grading and drainage and paving is required. There is also some landscaping requirements, that a landscaping plan was not submitted. And I don't know if we saw a landscaping plan on that site plan just now. So, right. So if the appellant could address that possibly, Madam Chair.
Madam Chair, actually, and Liz, thank you for raising that question. I actually, as I was thinking about the motion, was feeling unsure whether all of the items had been addressed. So I too would be interested in hearing that, Madam Chair.
Thank you. Ms. Mumford, can you explain? Yeah, because one of the variances is requiring 10-foot landscaping and a landscape plan. And we did see a slide about what type of bushes I think you were going to use, but it wasn't in an exact landscape plan.
Yes, so no, it's not, we don't have an exact landscape plan, but we will address the landscaping. We just have to go back because our architect, our architect that we use for this job, he passed away. So we need to get another architect for the landscaping portion of it, for the landscape architecture.
So, Madam Chair, to Ms. Mumford, so you do not at this point have an architect that you've retained to work on this project with you. Is that correct?
Correct. He passed away. So we're getting another architect that's going to do the landscaping portion.
Right, but you do not have one at this point.
Correct.
Okay, all right. Madam Chair, this case has been postponed. This is the third time they've come before us, but they clearly are having an issue with an architect and they need to get one to represent them. So it seems that given that alone, and the lack of preparedness to cover all of the variances, the information is lacking on the variances. It seems that maybe it's in order to give them another postponement so that they can get themselves pulled together and get their presentation in order.
Yeah, I don't think a lack of an architect is a reason, but I do feel that overall that they have a lot of things that we need to see that we don't have here today. So I will agree with that. And considering that we have had most of the testimony today, that I'm okay with postponing it, and that if they come back, then we don't have to hear all of this all over again. We'll have most of this on the record, and we can just go. We can just go forth from the appellant, supplying us with the parking lease agreement, showing that the parking area is paved and drained, as well as the area you're going to share with the neighbor, and where your landscaping strips are going to be, as well as a laid out landscaping plan. So go ahead with your motion, Ms. Faith.
All right. Madam Chair, with regard to case number 21-181, I move that we postpone this case so that, as you just stated, the appellant and the appellant's agents can prepare specific information detailed to the variances that are stated in the agenda, and that the presentation is geared towards the Board of Zoning Appeals and the required information that we need to see.
All right, can I have a second, please?
Member Brown, I second.
Ms. Brown, second. Go ahead, call the roll, Ms. Kukla.
Ms. Barnes,
Yes.
Ms. Brown,
Yes.
Ms. Faith,
Yes.
Ms. Britt.
Yes.
Okay, Madam Chair, we need a date. What's available is March 21st and or March 28th. We could go further into April. We have April 4th and April 11th. It is up to the board, of course.
Yeah, I'm just gonna ask Ms. Mumford, how much time do you think you need?
March 21st is good.
Okay, are you sure you'll have everything you need by then?
Yes.
Okay, we'll put it on March 21st.
Madam Chair, just one thing. We are aware of the fact that CDCs do have meetings only certain times of the month. Perhaps we can hear from the CDC if they would be able to get them in before the 21st, because that is approximately, I don't know, 3 to 4 weeks away.
Yeah, I mean, my position is, I mean, we would like to have a community meeting, but that's not a requirement. I'm more just needing the appellate to have everything they need for the variance review for us today. So if the CDC can get them in, that's great, but that's not a requirement to come back to us on March 21st.
Thank you, Madam Chair.
And Ms. Mumford did state that she will be prepared by March 21st, correct?
Yes,
did.
correct.
Okay, all right.
And if you start getting through this and you realize that you're not, please let us know before March 21st, and we can, postpone you again. But don't wait till the last minute if you feel like you won't have this stuff prepared.
Okay. Okay, thank you.
All right, thank you.
Okay, Madam Chair, with that concludes our cases for today. We're on to old business.
All right, old business. What's this 1 and 4 list?
1, 3, 4.
So, Madam Chair, with your review of the resolution for 2192, I believe everyone received it, and is everyone satisfied with it? We can go forward with that one. So it would be 1, 2, and 4. I wasn't able to finish calendar number 22008 before this date, so we need another week.
Okay, no problem. Without objection, board?
Without objection, I'm good with that.
Without objection.
All righty. Well, we're done.
Great.
All right, everyone have a good week.
Good week to everyone and be safe.
Yeah, Madam Chair, we have the request for reinstatement. All right, our rehearing, that's the thing regarding 4705 Bridge.
Yeah, I thought our attorney told us she didn't have time to review this, so we have to review the reinstatement after we hear from her. Is that correct, Ms. Wagner?
We did receive 2 last week. I'm not sure if she was speaking of that.
Yeah, I'm trying to remember which is which. One of them I did review.
I believe it's the Canaz one.
Right.
I think the one I did not have time to review was the one that came in Friday afternoon for.
That was Hessler.
Yeah,
that's
Hessler.
Oh, okay. Yeah, no, I believe we did discuss. Yeah, my bad. I do believe we discussed this Canaz one, and surmise that there was not any new information to reconsider the case. Is
That is
from our
correct.
board? Right, okay, so,
That was my understanding as well.
okay, all right, well,
Yeah.
but just for official, can I have a motion to deny the reconsideration?
Madam Chair, I motion with regard to calendar number 21-192, a request for reinstatement based on
Consideration.
discussion. Consideration, yes.
About that.
Consideration for reinstatement that we go ahead and deny that request.
Can I have a second, please?
Ms. Barnes, second.
Ms. Barnes, second. Go ahead, call the roll, Ms. Kukla.
Thank you, Madam Chair. Has Ms. Brown left the call? I'm sorry. Oh, no, there she is. Sorry. Ms. Brown?
Yes.
Ms. Barnes?
Yes.
Ms. Bates? Ms. Britt?
Yes.
The request for rehearing on 21-192 has been denied. We will write a letter and send the applicant a letter. I mean, sorry, we will write a letter and let them know the decision here today.
Or that, either one. Okay. All right. All right, I think that's it. All right, thanks,
Something
everybody.
that works. Thanks.
Yeah.
Thank you,
Have a good week,
everyone.
everyone.
Guys, I've lost my assistant, so bear with me. She was so great, and now she left me.
Yeah.
We have the job posting is out there, so, and we've received 2 applicants, I think, so far. It's really only been out for maybe 2 days, so they're coming in.
All right.
Keep me
Liz,
posted on.
can you send us the link to that? Maybe if we know someone.
Yeah.
Oh, sure. So right now it's in-house.
Oh,
So
it's only in-house.
Okay.
Yeah, I can't.
All right.
I can't post it out yet. So sorry
right.
about that.
You could still pass the word.
Yes, you could talk about it, but you know,
Yeah.
if I
Well,
find somebody great in the city, you know, if I find somebody already here, and
Yeah.
that's the
That's
quickest way.
that's much easier. Yeah.
Right. Yeah.
Yeah.
So.
Well, and that's proper protocol. So.
That's right. That's right.
But if you can send if and when you can send it out to us, do so, and we'll